Finally, People versus Baird. Mr. Markou.
Madam Chief Justice, may it please the court, Anastase Markou on behalf of Rich Baird, along with Randall Levine from Levine & Levine. Mr. Baird's argument in this case is not novel, it's not new. Since the enactment of the Judicial Inquiry Statute, the legislature, this honorable court, scholars, and the bar have all understood that those charged with felonies after a judicial inquiry are entitled to preliminary examinations. We're here about statutory construction, as Justice Viviano pointed out. We have language that says, shall proceed in like manner as upon formal complaint. The word complaint has to take on special meaning given that phrase. It's not a mandatory process. I'm sorry, it's not a permissive process. It's not a probable process. It's a mandatory process. In 1917, when the Judicial Inquiry Statute was enacted, Michigan had over 50 years of charging individuals by complaint and warrant. There's no question that's true. That was a mechanism to initiate felony and misdemeanor proceedings separate and distinct from citizens' grand jury charging process. In 1917, when the Judicial Inquiry Statute was enacted, Michigan had a well-established practice and procedure in place where those charged with felonies by complaint had a right to a preliminary examination. So when we look at that phrase, shall proceed in like manner as upon formal complaint, it was what the legislature understood in 1917 because it had been over 50 years that the state of Michigan had been using the complaint process. So when they used that phrase, they understood full well what complaint meant. The other phrase that is used is the disqualifying phrase for those who conduct the inquiry from being the examining magistrate. We know that in the McCormack case, this honorable court, prior to the changes in the law, found that the judge who conducted the inquiry could be the same judge who did the preliminary examination. In 1947, the legislature had a full and complete opportunity to state clearly the people's position here, that there was no right to a preliminary examination by completely making that abundantly clear. Instead, what they did is they moved forward, understanding what the phrase shall proceed upon formal complaint meant, and added the additional language that the examining magistrate cannot be the same person who is part of the judicial inquiry. We have concerns raised by Justice Bernstein regarding why or what harm we might have right now because we do not have a preliminary examination. We've also heard public policy arguments for the people about why there's no need for a preliminary examination in this case. But fundamentally, the statutory language itself supports our position, and so does common sense. You can't read a statute to not make sense at all. Justice Viviano asked the question of the people, well, if it's probable or possible there's a prelim, what standards apply? If that's what the legislature meant, there would have been some language, common sense language in the statute to decide what standards to employ in deciding whether or not the person's entitled to a prelim, which judge is the one that gets to make that decision, the one who conducted the inquiry or the judge after that. Can a defendant ask for the right to a preliminary examination? None of those standards are in there, Your Honor, because it doesn't make any sense that it's possible that we have a prelim. It's a mandatory right, and that's why the standards are not in that provision. There are reasons why we have a preliminary examination and why this is different than the citizens' grand jury. In a citizens' grand jury, we have citizens, multiple citizens, deciding whether or not someone should be charged. And here we have a judge, single judge, member of the government, acting as the judge conducting the inquiry. That's a different circumstance than a citizens' grand jury. What are some of the reasons why preliminary examination makes sense and why we know that the mandatory language the statutory construction argument that we've made actually makes sense, is that in a prelim, you have an open public forum in front of a separate judge. The rules of evidence apply. They don't in a judicial inquiry. Constitutional suppression rules apply in preliminary examinations, not in a judicial inquiry. Defendant is entitled to counsel at a preliminary examination, not so at a judicial inquiry. Defendant can cross-examine witnesses, not so at a judicial inquiry. Defendant can present witnesses, not so at a judicial inquiry. The defense can present evidence, not so at a judicial inquiry. The examining magistrate has to assess to some extent credibility before making that determination. And fundamentally, when you have a process in place, shall proceed in like manner as upon formal complaint, and you have a different judge doing it, what you guarantee is you have a process in place to ensure that there's some fairness to the defendants who are charged after a judicial inquiry. And that process includes not only everything that I just outlined, but what about the right to bring a motion to quash after a preliminary examination based on improper probable cause determinations or mistakes in law? We have none of that under the people's point of view. It's just a judge, member of a government making this decision. The reality is, and I know that it's been used frequently, the judge conducting the inquiry is not a grand juror. It's not grand. It's a single person. It makes little sense that they call it a grand jury. It's not a jury. It's a judge. It's not the citizens acting as a way in which to decide whether or not a fellow citizen should be charged. Fundamentally, this statute is an inquiry statute. It's an investigative statute. It uses the word inquiry, I think, over 30 times. I think it might mention grand jury once in 767.3. Does not in any way in 767.4, which is the main statute we're here on. And the reality is that from time immemorial, since this statute came about in 1917, every case that this court has had on this particular issue, either the defendant waived their right to preliminary examination or the person had the right to preliminary examination. You've seen the scholarly articles that have been submitted by Mr. Garowitz and his group. Every person who's talked on this subject assumed that there was a right to and identified the right. The Barr article from 1947 specifically says there's a right to preliminary examination. Again, this isn't new or novel. The new or novel position, and the reason why it's new and novel is because it's wrong, is that there is no right to a preliminary examination. That's a new and novel position. That's what Judge Kelly found, and she was wrong as a matter of law. Do the judges have any questions for me?
You may reserve your time for rebuttal if you'd like.
Thank you.
Absolutely.
Good morning again, Your Honor.
It's good afternoon.
Your Honor.
No fire-free zone, you've been up here enough. Let's just start with some questions. Is there any instance you can point out to me where a formal complaint is filed and there is not the opportunity for a preliminary exam?
Your Honor, I would point to the one-person grand jury statute. Is there any other one? No, not that I'm aware of, other than I
But
suppose.
when the statute says and shall proceed as if a formal complaint has been filed, doesn't it mean that you pick up from there? And then, as I understand it, once a formal complaint's been filed, there's an opportunity for a preliminary exam. You might waive the exam, but there's an opportunity that follows after that.
So, Your Honor, well, I'm trying to figure out the best way to answer that. Your Honor, the problem with that argument, if I may, respectfully, is that the language before that is the judge having jurisdiction. So if a felony indictment is returned, that indictment is returned at the circuit court level, where obviously there is no right to a preliminary exam. And if I may add to that, Your Honors, in this language, in this statute, okay, I understand it says that the judge conducting the inquiry shall be prohibited from being be the examining magistrate, trial, hearings on the complaint or indictment. Your Honors, to read this statute the way the appellant wants you to would create a right to an exam for a misdemeanor. Because if the court wants to say, well, examining magistrate means there must be a preliminary exam, Well, it doesn't limit examining magistrate to indictments for felonies or for misdemeanors.
But not really, right? Because a complaint in district court proceeds one way if it's a misdemeanor and another way if it's a felony. And I think we're all familiar that the felony proceeds to a preliminary exam and a formal complaint and a misdemeanor does not, correct?
Your Honor, except that the the appellant's argument is that the fact that examining magistrate exists must mean there is a right to a preliminary exam. There seems to be no limitation on that in this language.
I didn't hear that. I heard them to say that must mean in the case where the charge is a felony, that the judge who issues the investigatory whatever we think it is can't possibly be the judge who sits on the preliminary exam. But if it's a misdemeanor, I believe this. They'll correct me if I'm wrong. What counsel on the other side is saying, that wouldn't apply. It's just.
Your Honor, I understand that's the argument. But if their position is that the mere existence of this phrase automatically guarantees a right, there's no limitation on. I understand that that's what we think. But if we're talking about looking at the statute, there's no limitation on what examining magistrate applies to. And that's the problem we get into, and that's why we acknowledge in our brief, this is not the greatest worded statute. I mean, it's clear that the citizen grand jury statutes, there are like 30 of them, and they're all maybe a couple sentences, and for whatever reason, the legislature took like 10,000 words and crunched them into 2 statutes. And so it is a problem. But according to, if their judicial philosophy they'd like this court to use, is that, well, examining magistrate must mean there is a right to an exam. There is no limitation on when that right, because it says.
But before you get to that is the provision that says proceed as if a formal complaint has been made. So don't they go together? And when there's a formal complaint, if it goes to the felony stage, you're entitled to a preliminary exam. And then there's a provision that says that the examining magistrate can't be the same person to preside over the exam. Why don't those 2 provisions, when they're put together, suggest that when there is a one-person grand jury and an indictment issues, upon issuance, you proceed as if the formal complaint has been made? As I understand it, a prosecutor will investigate, request a warrant, they'll issue a warrant, and then it goes to a district court. The district court will have a hearing to determine whether there's probable cause, and then they sign a warrant, they sign a complaint. Then once there's a complaint, there's a 7-day period where you'll have a preliminary meeting to decide whether you're going to have a preliminary exam and whether there's any stipulations that can be made. And then you proceed to the preliminary exam. And so with that understanding, it seems to me when they use the language as if a formal complaint has been made, that's where that case picks up. And then you combine that with the following language that says that you cannot, the magistrate who does the grand jury cannot proceed with the examination. Together, they would suggest that there's a preliminary exam right there.
Your Honor, I think I shouldn't say I think, the truth is there is a lot of this that is unclear, and that's why the first place we have to look is to the statute and where the statute expressly creates rights and where it doesn't. And I think it's important to also look at the context of what we're talking about here. Mr. Markou talked about all the things that don't happen in a one-person grand jury indictment. But they also don't happen in citizen grand jury indictments. There is no right to cross-examination, just like in a citizen grand jury indictment. There is no right to, the rules of evidence are not applicable. That's true in also a citizen grand jury. This is also how the federal government, I know that's not the issue here, but this is also how the federal government goes forward. I think what's more important is perhaps to look at the similarities between the 2 bodies, between a citizen grand jury and a one-person grand jury. Both are comprised or put together to investigate crime. Both have the ability to compel witnesses to testify via subpoena. Both have the ability to punish witnesses for not cooperating via contempt. Both have secrecy provisions. In both, a prosecutor may participate. Both make really there are 2 probable cause findings with respect to the initial probable cause to start the process, and then the second probable cause finding that there's probable cause to suspect a crime has been committed and that this defendant may have committed it, just like a citizen grand jury, and just like in a preliminary exam case. You have that in.
The citizen grand jury just feels like a terrible analogy for it. It doesn't even feel like apples and oranges, it feels like apples and asparagus or something. You know, the difference between people, citizens, my neighbors standing between me and the government standing between me and the government just doesn't work for me. But you're right that there are, you know, we have lots of ways of investigating crime and lots of probable cause findings that are separate from the one that's made at a preliminary exam. So if the Attorney General asks the state police to do an investigation, the state police wouldn't come back to the Attorney General and say, file these charges unless they believed there was probable cause to believe a crime was committed, right? So there are probable cause findings in lots of criminal investigations that precede preliminary exams, am I right? So why isn't the judicial investigation, inquiry, whatever we want to think of it, more like a state police investigation or inquiry? So the probable cause that's set forth in 767.4, why isn't that just like the probable cause we expect the police to find before they bring a charge to a prosecutor? It feels to me like it's investigatory probable cause, not the kind of probable cause we expect a judge to find. Why isn't my analogy better than yours?
Sounds like a loaded
Trick
question. Your Honor, admittedly, there are the multiple kinds of probable cause findings. And actually, I'm glad you asked that because I found some case law late last night. It's an unpublished opinion. It's from the Court of Appeals in Retailer, decided October 27, 2015. And I'll try and read this quickly because I know my time is coming. But it says both MCL 7673 and 7674 reference probable cause. However, the nature and the quantum of evidence available at the two stages of the proceeding are not the same. A request for a grand juror under 767.3 may be available upon information and belief and is more likely to be based upon documentary evidence and hearsay rather than sworn testimony subject to cross-examination. In contrast, a grand juror under 767.4 may require the testimony and production of evidence pursuant to subpoena, and by that power may undertake a more probing and thorough investigation than the petitioner. Here's the culmination. Accordingly, while each provision requires a finding of probable cause, the former requires probable cause sufficient to justify a formal and confidential investigation. The latter requires probable cause sufficient to bring criminal charges and have the matter heard in public trial. So those are the two separate kinds of probable cause, Your Honor. There's the get the investigation going, but then there's the real examination of evidence. And I understand the court's concern.
Wait. You need probable cause to get an investigation going?
Yes.
I thought you could, really? I can't start, the state police can't investigate crime before they have probable cause to believe a crime was committed?
Sorry,
that
I
feels
meant-
really unsafe to me.
Your Honor, I meant probable cause to get the one-person grand jury going. That probable cause. That's what I'm, sorry. And the way that relates to a informational case, let's say, is you have the probable cause, it's called like the swear to, where a judge will read a complaint, and then there's that probable cause finding, but then there is this other probable cause finding after there has been an examination of the evidence. Now, let's be clear, Your Honors, I understand, and Your Honor, I see my time is about to run, but I'd like to address your point, if I may.
I have another question for you too, so go.
Awesome. Your Honor, the idea that the judge is a member of the prosecution's team, for lack of a better phrase, or is part of the government. Understandable, I could see how one could have that perception, but the reality is that is not how this process goes. The one-person grand juror is an independent body, and the one-person grand juror may request the prosecution's assistance, just like a citizen grand jury. I know you don't necessarily like the asparagus or I'll be the apple, but they don't have to. It is an investigation, not in a traditional sense like, oh, you have the police and they're out, doing that kind of investigation. The one-person grand jury can take a broader look at everything. The one-person grand jury is not limited to, in a preliminary exam, Your Honors, I know that, you have, as I said, you have the prosecution, they put on a case, and the one-person the district court judge is kind of limited to whatever's in front of them. The one-person grand juror has such a broader power because he or she can take whatever information they deem is appropriate, and they can make the determination as a member of the judiciary, as this court said in Slattery and Colacasitas. I'm not sure why everyone thinks we just think it's Colacasitas, that any grand jury, whether one person or citizen, has always been recognized as exercising judicial power. And so you have an independent judge, maybe acting as a grand juror, but an independent judge making their own probable cause determination. Whether the prosecution is presenting evidence or not doesn't change whether you're at an exam or at a one-person grand jury, because you still have a judge making that legal determination.
All right, these are short questions. You said
Yes.
you had experience, that as a defense lawyer, you encountered a number of these. Can you give me more information about that? I'm just curious. In every county, in lots of counties, what was your experience?
No, Your Honor, it was primarily in Wayne County, and the way that it would work is that, and I see Justice Zahra nodding his head, the way that it would work is you would get a call from the chief judge's clerk, whether it was Judge Kenny or whether it was Apprentice Judge Edwards, and they would say, Mr. Kessel, we have a one-person grand jury indictment for you. Would you like to come and take it? And of course, I always would. You go to the courthouse, and your client, whether he's in custody or he or she, I should say, is in custody or not.
That's helpful. I don't mean to cut you off. But any other counties where this happened? I'm just curious. I'm literally just
No,
curious.
not that I've ever done.
And did you have any understanding of why that process was being used in Wayne County as opposed to the traditional public charging process? Why?
Your Honor, initially as a young attorney, I think I probably just assumed that was the way it was supposed to go. However, once I started doing more and more of them, because admittedly, as a defense attorney, yeah, I wanted to have a preliminary exam, and then I started looking into it and realized that this is just a different prosecuting method, which I would note, Your Honors, that...
But so the answer is you don't really know why? In
No,
one
well,
case versus another?
well, no,
I'm just trying to understand. I'm really, just curious.
No, I guess my question is, are you asking why the prosecutor would use it in
Yeah.
certain cases? Mm-hmm. Your Honor, there are a number of reasons in Wayne County they used it. I will tell you that my experience was that these cases in Wayne County were almost always involving crimes of violence, and that a victim would testify in a safe setting as opposed to a preliminary examination.
So a case where doing it not in a public proceeding was beneficial to the witnesses, perhaps, or the victim, perhaps?
That's correct, Your Honor.
Okay, understood. I'm literally just trying to catch up. And one last question.
Of course.
You said before that the judge doing the investigation becomes part of the prosecutor's team. You probably didn't exactly mean that turn of phrase, right?
I think I meant that that it seems like this court's understanding is they are a part of the
I see.
team,
That's
but it's that they're
we were-
not. Yes, they're very
Okay,
much not,
okay.
Your Honor.
And do you have any concern about putting aside constitutional questions, statutory interpretation questions, all of which we're trying to sort out, about just the appearance of putting the judge in the position of making charging decisions? I mean, there is enough of a public confidence issue about courts, right, and about the rule of law. Do you, as a member of the bar who cares very much about this institution, think is it helpful to us to put judges in the position of issuing charges?
Your Honor, I owe this court complete honesty, and I may get yelled at for it later. But, Your Honor, when I was a defense attorney for a long time, there were a lot of prosecutors that I trusted and respected, and quite frankly, there were some that maybe I didn't. And I would have 1,000 times a day and twice as many on Sunday. I would rather have an impartial judge who was not vested in prosecuting in cases and didn't necessarily owe duties to anybody else other than to be honest to the bench to make those decisions. Now, of course, are there judges that, look, you walk into the building and if you have Justice A, you're like, oh, great, this might be good for me, and oh, you have Justice or Judge B, and you're like, oh, maybe this isn't going to be a great day. But even though judges inherently have those differences, I think that I personally would understand and maybe appreciate this impartial judge at that level making that decision, as opposed to sometimes, prosecutors making decisions that I personally didn't think appropriate. But
Thank you.
that's just me, so.
Am I right, though, that the way the system operates, the police investigate and submit a warrant request to the prosecutor's office? If the prosecutor thinks there's enough to go forward, they will write a warrant and a complaint, but it's presented to a district judge. And only if the district judge believes there's enough there will it proceed. That's the way it works, isn't it? So
Yes.
What's the difference between that district judge in that instance and the one-person grand jury making that same determination? It's still a judge who's making it.
Absolutely, Justice Zahra. What I would like in that initial probable cause finding that made by the judge is I'd refer back to that language I quoted in Taylor, where you have that initial probable cause finding that is based upon, a small portion of evidence, which, they talk about it's potentially hearsay, it's potentially inadmissible things, but the judge makes that initial probable cause finding. Then there is a second probable cause finding that takes place after the evidence has been considered. And it is that probable cause finding that happens at a preliminary exam. It's that probable cause finding that happens as a result of the one person's grand jury's inquiry. And I will, I suppose, potentially close by saying that it can't possibly be a coincidence that the language of 767.4 and this court's repeated recognition of why an exam exists is to establish probable cause that a crime was committed and that this defendant committed that crime. That's all defendants are entitled to, this finding of probable cause. They have trial rights that they can exercise down the road. No one's questioning that. But at this stage, defendants are entitled to a probable cause determination, whether by a one-person grand jury or citizen grand jury or an examining magistrate. I thank you for your time, your honors. Thank you very much.
Thank you for all of your patience with our questions.
Justice McCormack, so Randall Levine's been practicing for over 40 years, criminal defense work in Southwest Michigan. I've done it for over 25 years. This is the very first case we've ever had involving a judicial inquiry. It's not a common practice on that side of the state. I've never seen it happen. So to the extent the court is asking about our prior experiences, we have none of that. Justice Zahra, there were some questions asked about our understanding of what this statute means. Your understanding is exactly what we're trying to state here. Shall proceed in like manner as upon formal complaint means a complaint. Misdemeanors stay in district court. They have the right to a trial. It says in the statute that the same judge cannot be the one conducting the trial. And for those charged with felonies, they then have the right to a preliminary examination. That language, examining magistrate, just solidifies and makes it abundantly clear that that is what the language shall proceed in like manner as upon formal complaint means.
What do we do with people versus glass? People versus glass. Is that an impediment in any way?
It is not.
Why not?
Because that dealt only with citizens' grand jurors. In the citizens' grand jury statute, there is no language that says shall proceed in like manner as upon formal complaint. In the citizens' grand jury statute, there is no language that says the examining magistrate shall not be. It's just different statutes with different languages. And so because of that, they are distinct and different in kind. So I don't believe that glass is, what's interesting about glass is they only overruled a portion of Duncan. The actual language was, we only overruled Duncan to the extent it exceeded its rulemaking powers, meaning that it was not overruling Duncan on any other part of the decision. Duncan's other part of the decision was clear. In judicial inquiries, you have a right to a preliminary examination. In citizens' grand juries, by statute and through the long history analysis they did, you don't have the right to a preliminary examination. Does the court have any other questions?
I don't see any. Thank you all. This case will also be submitted, and that concludes our case call.